On to topic number 2, I want to discuss tonight another important story. Today, Elgar Parishad case accused. A father, a priest, a tribal rights activist, a terror accused, and an 84-year-old man, Father Swamy, passed away. Many of you may already be knowing who he is, for whom he fought, for whose rights he stood up, and what he dedicated his life to. An 84-year-old activist and a priest, tribal rights activist from Ranchi, founder of the organization Bagaicha, fought against illegal detention of minors who were labeled as Maoists and put behind bars. And that's how he spent his life. He was made an accused in this Elgar Parishad or Bhima Koregaon violence case, as it's also known as, and arrested by NIA on October 8th, 2020. Perhaps the oldest person to be charged under UAPA, our anti-terror law. 84-year-old Swamy was charged under the UAPA, which is why to get any kind of relief for him was very difficult. Not because there was so much of proof of this wide-scale terrorism that he was carrying out in our country, but because he was booked under the UAPA law. So even when he wanted a sipper and a straw, because his body was so weak that he couldn't get up to drink water, and that because he suffered from Parkinson's, it just made it so much more difficult for him to hold the glass. Despite the fact that he had a hearing loss problem, he had hernia, lumbar spondylosis, and at one point got COVID. He hadn't yet gotten bail. Today was his bail hearing. But just before his bail hearing, he passed away. We found out when it was mentioned in the court. To the shock of everyone, including the High Court, it was a shocking point when it was announced that he is no more. Where the Bombay High Court said, with all humility at our command, we are sorry to know that he has passed away. We are shocked. We passed orders for his hospital admission on the first day. They even gave him an extension recently. They even ordered that he be shifted to a private hospital. Now, we can't, and I am not going to sit here and assume and say that Father Swamy is not with us anymore because we didn't give him timely medical help. Can't decide. But I do want to, tonight, on the day that many are mourning his loss, I do want to take up this time to talk about what he fought for and what his latest petition was against the UAPA charge, and whether people, depending on them, their actions, the evidence, depending on basic human rights, depending on what is everybody's right to a dignified life, whether those people can be given a little bit of relief, even under UAPA. When an 83-year-old man has to fight to get a sipper and a straw, when his lawyers have to fight to get him to a hospital, to get decent medical attention, when the Human Rights Commission has to step in, and when large groups of lawyers and activists have to lobby about it, then there is a conversation here. Does Terror Act of our country override the basic human rights? Father Swamy may be no more, but I do still want to have this conversation. Did we do justice by him? Should an 84-year-old man suffering from Parkinson's and whatnot be rotting in a jail as a UAPA accused, a man who spent his entire life fighting for tribal rights? I say good evening to Aarti Sate, lawyer and spokesperson for Maharashtra BJP, Trisha Shetty, advocate and founder for She Says NGO, Prem Kishan Jain, former ADGP for Maharashtra Police, Swapnil Kothari, senior lawyer, and Mr. Suhas Chakma, director for Rights and Risk Analysis Group. And Mrs. Chakma, if I can start off with you on this conversation, what was a part of his latest petition and what has been a part of a debate for a while, whether basic human rights and right to dignity really factor in when UAPA is at play?
Radu, there on the TV, please.
I think there are three elements into it. First of all, I think it's the presumption of innocence. That when somebody is charged with UAPA, then that person actually loses the presumption of innocence because of the way the bail conditions are put and the way that person cannot get bail. The second issue which I want to mention is, of course, India has to fight terror, but there is something rotten when somebody says that an 83-year-old man suffering from Parkinson's disease, who cannot hear, who cannot look after himself, actually poses a threat to the territorial integrity or sovereignty of this country, that the state has to retain him in detention and kill him in custody as an innocent man. He has not been convicted, so he is innocent. It's a custodial death because he died in judicial custody. The third point which I wanted to mention is, I think if this is the way the government of India is going to define terrorists and terrorism, I can tell you nobody in the world will support a UN Convention Against Terrorism. If you look at the UN Convention Against Terrorism, it's the India which is sponsored at the UNGA. But today, with what moral authority the government of India tell the people, the international community that an 84-year-old man had died in custody and he was a terror accused despite suffering from Parkinson's disease. So it's a failure of the state, it's a failure of the judiciary, it's a failure of the national human rights institutions that you could not secure bail a person who actually was accused in a case which took place in 2017, and you have arrested him almost 4 years down the line. So, what evidence you have been gathering in all these things, and what do you gain by detaining and keeping in jail, except that the state wanted to show that how cruel it is. And I think they have been able to show that the state is very cruel, and they have been quite successful in it. So it's not only the central government, I think it's the NIA itself which has to introspect, when they are charging people. And of course, the Maharashtra government, and never forget the stringent provisions which we see today in the UAPA, we are brought by the Congress itself.
Yes, and it's absolutely. So let's break it down there then. Trisha, would you want to come in here? Where did we, is it the government and the NIA that has failed us today, or is it the judicial system, or is it just because the law is designed in such a manner? What is it?
Today we've lost a patriot, so really no more to not call the truth for what it is. Who else was accused under the UAPA? Pragya Thakur. Funny enough, the NIA did not object to her getting bail. Funny enough, she goes to NIA court and demands that the courtroom is too filthy for her, that she needed a cushion to sit on. Funny enough, Pragya Thakur has got a ticket and is now a member of parliament, despite having credible evidence against her and being charged under the UAPA. But a senior citizen who's dedicated his entire life to fight for the rights of the land rights of Adivasis, to fight for the most marginalized, whom there was no credible evidence till date that has been presented against Father Stan, did not even get access to a straw. He was jailed in October. He had to wait till December 4th to receive a straw and sipper. And the NIA said, we never confiscated a straw and sipper. How can we return something that we don't have access to? He was not afforded basic access to dignity, to right to life, to right to health. And we should not forget that just because you're imprisoned or accused of a crime does not mean you lose access to your fundamental rights. He stated multiple times that when he entered when he entered Taloja jail, he could walk by himself, he could feed himself, he could clothe himself, that his condition has deteriorated after being imprisoned under false charges. I am going to say it's false charges because where is the evidence against him? We know what has the, even when we talk about Rona Wilson and the hard drive and the computer, where they claim that they found the letter alleging a conspiracy against our honorable prime minister. There has been clear allegations that there was malware that was used to insert these documents. A government that is so obsessed with wanting to trace original documentation on WhatsApp, why is it not traced who the original sender is of these incriminating documents about allegations to, assassinate our honorable prime minister? So let's just be honest and call it what it is. This is state-sponsored murder. This is abdication of responsibility of a judiciary which did not do right by Father Stanley, and they murdered him. They murdered a man who was not as significantly, whose health was not deteriorated to this extent, a man who consistently asked for bail on humanitarian grounds, on health grounds, who was denied. Why? Because he dared to dissent and fight for the rights of Adivasis. And that's just the state of the Indian democracy today.
Well, the NIA arrested Father Swamy from Ranchi on October 7th and then brought him to Mumbai. He was sent to judicial custody on October 23rd, and that's when they named him in the supplementary charge sheet. Significant evidence is yet to be presented in the court of law against Father Swamy. A lot of what was claimed earlier of we have found this and we have found that is yet to be also shown and proven in court, as is now an instance that we are seeing in many cases where all claims are made in the first week or two. A lot of noise is generated, but when it actually comes to test it and for that evidence to be examined, it's nowhere to be found. And this seems to be headed in the same direction. But Aarti Sate, do you today agree that we need to look at some aspects of the way this judicial system works? Was it fair for an 84-year-old to be languishing in jail and to be begging and his lawyers to be running around for basic medical help and some winter clothes to be given to him?
First and foremost, it is rather sad that Father Stan Swamy has passed away, and may his soul rest in peace. It's rather unfortunate that he had to die in the circumstances, so he passed away in Holy Family Hospital. Now, coming to your question, what role the judiciary has to play, I think the judiciary has to play a role as per the case presented before it, as per the due process of law that the judiciary has to follow. And in this case too, the judiciary was following due process of law. Now, what could be the circumstances under which bail had to be granted is something which the lawyers of late Father Stan Swamy had to present before the judiciary. The judiciary had to take cognizance of it and give bail as per the established principles, and also if he's had asked for bail on humanitarian grounds, the bail should have been given or not given. That is a judicial decision, and that is not something which I would like to comment on. What I would really like to say is that Father Stan Swamy, late Father Stan Swamy, was shifted to the hospital considering his age, considering the fact that he was ailing for the last so many days. In fact, the state government had said that we would like to shift him to JJ Hospital, which is a state-run hospital, which he denied. He didn't want to go to that hospital. And that's why he was given the facility at Holy Family Hospital. Also, from the time he has been arrested, up until now, adequate and more than adequate facilities had been provided to him by the NIA. They never took him in police custody right at the inception, considering his age and his frail health. They took him to judicial custody.
Yes.
Now, and in that also, he was given all the facilities. Utmost care was taken even when he was brought from Ranchi to Mumbai. He was given a wheelchair. He was given, whatever, reading glasses, etc. Whatever was required for a man of his age and his health was provided to him. But if the bail was to be granted or not to be granted is a consideration which the judges had to take into consideration after hearing both sides. And maybe the judicial authorities or the judges felt it not right to grant him bail, or maybe the hearing was still going on and some decision would have come through. So me to really now comment on what the judiciary should have been done is rather incorrect, and I would refrain myself from doing it.
So here is one aspect that you did mention, and I want to raise it legally before I go to Mr. Jain, but to Swapnil Kothari. Swapnil, why did the NIA have to arrest a person whose custody they were not even seeking? And if that was the case in the month of October itself, when they picked him up and got him to Mumbai, didn't seek his custody, and so he was in judicial custody, then why did he still not manage to get bail, legally speaking, for so long, keeping his health in mind?
That's a very, very good question, Tanvi. And, that is something which even I was thinking about, that why judicial custody? If you are taking him under UAPA, then you might as well ask for police custody, interrogate him severely and ask him all sorts of questions under all sorts of pressure and duress and try to extract the information and the truth out of it. So this, in fact, raises, sort of a red flag into how the NIA is working as far as this particular case is concerned. And I'm certain if this bail hearing was heard today, given the fact that he would have been alive, I'm sure he would have got it. Because, the law is very clear on this, that the UAPA, if you do not present evidence that the court looks at it prima facie, it seems to be true. If it prima facie seems to be true, then the court will not grant him bail. But if you don't have the evidence, you have, put him in judicial custody, and you can't say that, look, he was very aged, that's why you put him in this judicial custody. Maybe he would have, suffered into police custody, then you might as well not even arrest him at all, just call him into question. So the law has to apply equally as far as that aspect is concerned, Tanvi. So the thing is that the fact that they have not done that, I'm sure he would have got bail. So that should answer the question as to whether he would have got bail or not. Because in Angela Sontake in 2016, as lately as February 21, also K. Najib both got bail. The High Court gave the bail to K. Najib, and the Supreme Court confirmed that, saying that we are not going to interfere with the High Court decision because these cases take a long time to prove, and you can't just incarcerate a person beyond reasonable time unless you have something very concrete against him. So, we are not going to keep him incarcerated. 14 and 21, both articles, which is equality and a right to personal liberty and dignity, of course, which is enshrined under 21, that comes into play. And on that ground itself, he would have got bail. Now, as far as the state's role is concerned in this, I think if the NHRC has sent a notice, then this investigation needs to be done whether the state acted swiftly in trying to get him medical attention. The court, in fact, I just saw on your screen that the court said that we've granted him, admission into a hospital straight away. So to accuse the judiciary would be absolutely something which, none of your channels ever do. And none of your channels would ever, you would even allow to do. So I would assume, or I would say with utmost humility, that the judiciary has been absolutely correct in doing what it has done. And this is the actual part of it, that they have granted him admission straight away on all the complaints made. In fact, the People's Union of Democratic Rights yesterday shot off a letter to the Chief Justice of the Bombay High Court saying that his condition was deteriorating. So, all these factors would have come into play and he would have got bail today. Now, as far as the NIA's action is concerned, this is where I would like to throw a little bit of light upon, and I would urge the Bombay High Court that even if this case is moot as far as, Stan Swamy is concerned, I think you should go ahead and look at the draconian provisions of the UAPA, particularly one or two. One is 43D5, which is this section which was, which the lawyers of Stan Swamy have said it's unconstitutional. And according to me, it is to a certain extent, and I would say that it is unconstitutional because it does not define, first of all, what a front organization. Under Schedule 1 of this Act, you have all these organizations which are so-called banned, and there is no notification in the official gazette as far as the MCC, which is the Maoist Communist Center, which is concerned, which is, I think, item number 25, or its front organizations or its formations. What the hell does formations mean? What do you mean by front organizations? If you don't define them, then how can you say that this is a formation or this is a front organization? So define them. Once you define them, then you are in a better position. Otherwise, this lets, a Pandora's box open where the state has got a power to say, according to me, this is anti-terrorist and, this is assailing the integrity of, unity of India. So let's block this. And they haven't even blocked this. Have they stopped public activities of this particular organization? No, they haven't. They just put these people behind bars. So this is where the NIA would have had a lot of answering to do. And I hope that after his death, NIA comes out and says, apologizes or, does something to the effect that at least, it pushes the court in the right direction. And lawyers of Stan Swamy urge the High Court to look at this UAPA provision 43D5. Because, funnily, Tanvi, the last point that I would like to make this, 43D5, you remember the NDPS Act during the drugs, case during Sushant's thing, there was this section 37 which does not allow you to grant bail unless and until you show that this person is not guilty of an offense, or if given bail, he is not likely to commit an offense. The Supreme Court has viewed that is in fact more stringent than in terms of not allowing bail, in terms of allowing bail, rather than this UAPA, which is more stringent in terms of not allowing bail. In the sense that all I have to determine is a prima facie true case. I don't give bail. That is where the interpretation of the section is then left to the great judiciary of ours, because the judiciary is the only thing which can right a wrong and, sort of compare it with the articles of the Constitution which prevail and have this supererogative powers over, rather supersede all the acts which are all below it.
Okay. Okay, so that is Swapnil's, view, and he's covered multiple points there. But to begin with what I asked him, which is something that he's been thinking about as well, Mr. Jain, to you that question. If the NIA didn't seek his custody after arresting him and he was sent to judicial custody, I'm trying to understand why since October till July he still hadn't got bail. Can we say it's the slow judicial process? Can we say it is because it is still the UAPA charge that was against him, or lackadaisical, or the NIA didn't ask for it, or the judiciary didn't look for it? Where does this delay come from?
See, Tanvi, I would start a little with a little background. See, there are thousands of people who are working or who are perceived to be pro the militant element in the leftist wing. Father Stan Swamy was probably one of them. The case was registered way back in 2018. It took the police or NIA almost 2 years to arrest him. Now, there has to be some evidence which was collected in the meantime, which led to his arrest and which led to the arrest of so many other activists, who are the overground activists, as Mr. Kothari just now said, the front organizations and all that. When I was looking after the special operations in Maharashtra, there were 53 organizations which were supposed to be working as the front organizations of the left-wing, LWE movement. Now, and there are a whole lot of other organizations which were the fringe organizations. They were organizations which were actively working on the ground, fighting the security forces and committing excesses against the public. So there must have been some evidence. I'm sure this evidence was presented to the court repeatedly, and this came under judicial scrutiny not once but many times. And every time the bail of many others, including Father Stan Swamy, was rejected. So there has to be some evidence on record. We cannot just go by presumptions that there's nothing against them. And he was held at the age of 84 when he was arrested, and he was straight taken to judicial custody. Maybe there were certain extraneous circumstances. I would like to quote the case of Professor G.N. Sai Baba, who was a wheelchair-ridden professor of Delhi University, and he was convicted in a case of assisting and hobnobbing with the left-wing extremists. So maybe in this case also, the NIA had some evidence which was presented before the judges, who took a conscious view that he should not be bailed out. As far as the other things are concerned, like providing him the medical facilities in the hospital, providing him a straw, etc., this, I think, somebody has blundered somewhere in a big way. Small things can be even procured and given to the prisoner. The prison authorities do not require the orders from the magistrate for providing the basic amenities to an under trial prisoner, under trial person. So I think as far as the incidents and the historical facts are concerned, see, it was a much bigger conspiracy. Started with the Algar Prishad meetings which took place in Pune towards the end of December 2017. January 1st, 2018 was when the violence took place. And that too, when generally 25,000-30,000 people used to come to Bhima Koregaon every year, that particular year, the gathering was more than 5 lakhs. And then the violence started from the word go. So it had to be. And the Algar Prishad and Kabir Kala Manch, etc., had been working for organizing this protest for the last 1 year. They had been holding various meetings in various district centers and village areas, rural areas of Maharashtra. And it is a known fact that the Maoist movement has been exploiting all fault lines in the society: agrarian, students, labor, caste, creed, color, class. All these fault lines are being exploited by them. So this was one. And during the investigation, when the police and the investigating officers went through various, soft material which was available on the computers, on the phones, etc., they must have come to some conclusion, and there is some solid evidence in their hand. Now, only unfortunate part is that under UAPA, the investigating officer is not supposed to disclose all these things to the court. The court must have been taken into confidence. Some secret report must have gone to the court. But all these things are not made public, which leads to a number of presumptions on the part of the participants, other people who want to view the situation from their own angle. Some people want to look at it sympathetically from father's point of view, and some would say it's a sheer process of law.
I'll bring in Trisha in just a bit on the legal case and the investigation and the evidence available so far. But here is a simple point, Mr. Jain. He was an 83-year-old man with Parkinson's and several other medical conditions. To begin with, was he such a big threat to our country and a terror threat to our country that he had to be put behind bars?
Tanvi, he must have been, because see, you cannot go his condition as of today. The NIA must have stumbled upon his past. Maybe we are not aware as to what exactly was his role. See, if you are aware of this thing, that the Nazi war criminals were hounded even when they were 95 years of age. There was a guy who was 93 years of age, and yet he was brought to justice. So it is not a question of the age of a person and the physical condition of a person at that point of time when he's facing the consequences of his actions. He must have done something. There must have been some history to it. Otherwise, in Poona's case, in the left-wing extremist case, a person would be arrested from thousands of kilometers away. It cannot be just chance.
Yes, well, I'll tell you why. It can be, and why I approach it with a bit of caution, simply for the fact, Mr. Jain, because this case turned political from day one, and even before that, because this case turned on its head 2 times. As the people in charge change, as the governments change, the case changed. Different set of people, different theories, different kinds of so-called evidence were put out in the media, then turned on its head, put out again. 2-3 years later, another agency comes, picks up a different, another set of people from another part of the country. So I approach it with a lot of caution, and I will not say there must be something definitely or there isn't anything at all, because it turned political from day one, unfortunately. Trisha wanted to come in.
Tanvi, I'll just take one more minute. I was IG Nasik when the first blast took place. I'll just take 1 minute. I was IG Nasik when the first blast in Malegaon took place. And in that case, certain individuals from a particular community were arrested. We had verified 20 times that those people were arrested. But the moment the government changed, the entire set of accused were changed, and these accused also were let off, and the new accused also could not face trial.
So we know this. We know it from Malegaon till now. This happens. We cannot ever assume until proven in a court of law or what has taken place. Trisha vehemently disagrees though with what Mr. Prem Kumar Jain is saying. Go ahead, Trisha.
Honestly, I'm not just embarrassed, I'm mortified on behalf of the previous panelist for even daring to compare Father Stan to Nazi murderers. I mean, it's just
I'm only giving an example. I'm sorry, Trisha, that was not the intention. I only told you. So please don't harp on the age and the...
Please stop embarrassing yourself further. You are asking about evidence.
Trisha, please mind your words. Please mind your words. What do you mean by embarrassing? I have a point of view. You have a point of view. I have a point of view. Please don't say embarrassed. I'm not embarrassed at my words at all.
And I have no...
I'm not embarrassed at my words.
Can I say what I have to say? I'm not interested in arguing with this person, or I can exit. I'm more than happy to exit.
Then please say that you are. What do you mean by feel embarrassed? What? All bloody bullshit.
Okay. One at a time, please. Let everybody put across their viewpoint. Trisha Shetty now.
One of the other co-accused, Vernon Gonzalez, one of the other co-accused. What was the evidence presented against him? His bookshelf, the CDs. You had the judge talk about why does he have books titled War and Peace by Leo Tolstoy. Okay, those were the great evidences presented. When he talks about the computer, your learned panelists before this, let's talk about Ronan Wilson's computer. So go Google the article that has come out by the Arsenal report that clearly says there was a Trojan software called NetWire used that conducted repeated cyber attacks to insert these problematic documents and evidence that was found that was later used to call this a whole conspiracy. When you're talking about evidence, what is the evidence? What is the evidence that you're tooting? You have no evidence. The evidence that you have used has been out of wild imagination over this original letter about a grand conspiracy to assassinate our honorable Prime Minister. That is a serious charge. If there is such a conspiracy, let's get to the bottom of it. Where did this letter come from? Let's investigate it. Why is that investigation not happening? So you're talking about wild things like leftist conspiracy. A great man has lost his life, not lost his life, has been murdered, okay, by a state and a complicit judiciary. If you cannot find your moral compass to come here and defend the truth, speak up for the small guy whose rights are being taken away by the state. Then you do yourself a disservice and have an intellectual conversation. If you can't have one, exit and open Google and educate yourself.
Mr. Jain?
Number two, you are talking of that particular report. It is still under judicial scrutiny. There's no final word on that. So please don't quote a report from a foreign country which has no value, which has no basis till the time it is proved true.
Yes, Suhas Chakma wants to come in, and then I have a question for Aarti. Yes.
No, I think if you look at the way the state operates, this incident which took place in Bhimakaragao was a freedom of association and assembly. Some people, if they have assembled 500,000, that doesn't make an offense that they are assembling there to assassinate the honorable prime minister of this country. We just had a case where in Assam, one of the members of state assembly was detained under UAPA just because he was protesting against Citizenship Amendment Act, and he was accused as a terrorist, and he wasn't allowed to contest the elections. And in fact, elections were over. He didn't campaign, and he won the election. And now he has been given bail in all the charges, including under the UAPA, of being accused as a terrorist. I think we have to understand that this case in which Father Swamy was arrested had political color prior to the election from day one. And I come from the Northeast, and I'm telling you, you do not know the terrorists. And you, DOA, you have been hobnobbing with the armed groups, including the National Socialist Council of Nagaland, which maintains the entire troops. You are allowing them everything, to have their own troops, to collection of taxes, everything. They are not terrorists. But the people who have assembled or who might have helped, if that is to be correct, that they are terrorists. I think we have a serious problem in this country. How do you define terrorists? National Socialist Council of Nagaland have more than 10,000 troops. The Indian Army cannot go in. They maintain their headquarters. Everybody in Dimapur and Kohima has to pay taxes, including the civil servants. And you are not interfering there. That's the terrorism. People assemble here and nothing is found. Then in the beginning, the Maharashtra police investigates. Then the NIA comes in. Then, of course, UAPA and everything comes up. I think we cannot deny the fact that these kind of cases are used for political purposes. And I am sure, the only purpose possibly why the Gogoi was, kept in prison in Assam was because he was a prominent leader. He could have influenced the election. So much prominent that without campaigning, he won the election. And today he is not a terrorist. He has been given the bail. So you cannot deny the reality.
Yeah. The politics of it cannot deny that reality. Swapnil Kothari wants to make a point. Go ahead.
Yes, Tanvi. What Mr. Jain said is an overview of the Maoist organizations and people associated with it, or people who are sympathizers with it. But when it comes to presenting concrete evidence to put a person behind bars or to make a person continue to be behind bars, that is where I have an issue, and that is where I have a problem. And that is why I was urging that 43D5 should be considered as unconstitutional, and it should go so that it's treated as par, where bail is the rule and jail is the exception. So what happens is that bail is given to a person, even if he's charged under UAP on ordinary lines, the way, that if we gave him bail, he's not going to tamper with the witnesses, he's not going to destroy evidence. Those are the standard grounds on which you grant bail. So this is where I have a difference with Mr. Jain, and this is the judiciary which can save us from this, for the simple reason that the legislature has enacted a law and the judiciary has to interpret it under the provisions of the Constitution. And that is where the judiciary, in fact, has done its best, whatever it could, as far as Mr. Swamy's case is concerned. And if earlier he was denied bail, then they would have given reasons in those orders. And as far as the interpretation of UAPA is concerned, that is where the judiciary would have had to take and should be taking a little bit of a more activist approach. That's my only concern, because Tanvi, you're going to face these cases, you're going to debate about these cases day in, day out, one way or the other. But I think as far as the legislation is concerned, the draconian provisions have to go or have to be diluted. Otherwise, this is going to present, we're going to debate one after the other on, there'll be a different case altogether tomorrow. And, it's not something which is a wholesome thing for our democracy at all.
Well,
Just
we know
because a
the
person-
most recent case again was when we discussed for about two of the activists who recently got bail only after they ended up going to the topmost court. And much conversation happened there as well when the High Court first gave them bail and there was massive opposition to it. I think there is a problem with the law to the point that it's also extremely subjective. While a lot of times we've seen examples where judges have said that no, if you are under the UAPA, then prima facie, if I am told that there is evidence to connect you to this terror act, you're not going to be left. But there are also examples like the Kerala High Court, which in the K. Najib case did give him bail, which was upheld by the Supreme Court, or even in the case of Varavara Rao, where finally on medical grounds he was given bail. Unfortunately, in this case, while the medical grounds bail plea was filed in the courts were actually the ones who first ordered that he be taken to a proper hospital, that Father Swamy be taken to a proper hospital. Perhaps today they would have granted him bail as well on these medical grounds. It was too late. Aarti Sate, there is one other aspect, which is why I wanted somebody from the Maharashtra government, one of the three political parties, to come here and answer us this question as well. When we debate the law, the use of the law and what NIA has to say and how they dealt with this case, problematic. But the other problem is how he was even treated when he was in the jail. If it is up to the jail authorities to have managed to give him a sipper or a straw or winter clothes or proper medical help at the given time. The jail authorities would take him to the hospital, bring him back the same evening at that age with all of those medical conditions. Those are some of the things, Aarti, that we need to question the Maharashtra government and ask them, why did your jail authorities not give him the due respect and due attention?
Surely, if the jail authorities have not acted in accordance with the needs and the demands of Father Stan Swamy, these are things which surely the Maharashtra government will be answerable for. But as information is provided to me, it was said that there were adequate facilities given to him. But if there were some anomalies which were noted, then surely we would ask the state government as to why were those facilities not given to him, especially in view of the fact that he was an ailing citizen, especially in view of the fact that he had a history of medical illnesses, and the High Court had specifically said that he had to really be moved to the hospital once his condition deteriorated. So that also really gives rise to another question, that maybe the jails are not well administered in the state, and that for that the state government should definitely be held answerable.
Yes, Mr. Jain, would you like to comment on this as well? Because at the end of the day, it is up to the jail authorities as well to provide adequate medical attention. Your basic human rights will begin right there in the way you're treated, even if you're inside the jail, when you're taken to the hospital at that age.
I fully agree with you. The medical facilities within the jail are absolutely primitive. And in this case, the basic requirement, as I earlier mentioned, that even the sipper and the straw, which was denied to him for a long time, and it was only given to him after the court order, is a very, very unfortunate development. This could have been easily done. We have expenditure heads for that. It would cost a pittance. These things which are basically required to sustain him should have been provided to him right away. When somebody has goofed, as I said, in a big way, and inquiry, etc., would again be thrown into some official jargon. But this has been a very unfortunate development as far as Father Stan Swamy was concerned at that time.
Completely out of time. I'm going to thank all of our panelists for joining us for this conversation. As I just leave this for our viewers to think about, few of the lessons that we should take from this. Father Stan Swamy is no more with us. It is unfortunate. His supporters, his followers, his backers, the lawyers, everybody tried as much as they could to provide him relief. But the fact that he was put behind bars for working with the Adivasis, supporting the tribals, fighting for their rights, and at some point appearing, perhaps being sympathetic to some of the leftist organizations. But to pick that up and to have connected him to a terror act, to say that he was using the money from the Maoists or the Naxals, that he was a Naxal himself, that he was involved in a conspiracy that led to the violence that unfolded in Bhima Koregaon, that he was somehow part of this entire other gang that was conspiring against the Prime Minister of our country, would need evidence. And that evidence needs to be shown. And up until then, and that happens, we need to think about the fact whether a UAPA law as it stands today, or anti-terror law as it stands today, is robbing people of their basic rights. Right to dignity, just a basic human right. And whether the way the system ended up treating Father Stan Swamy in his last few months, whether that was fair. And if it was not, if it was cruel, as I see it, then we need to fix this. The case could have gone on and the NIA could have proven, if they had the evidence, as to whatever terror activities it is that he was involved in. But even then, did a man who till as of now is just an accused, innocent man, deserve to be treated in such a manner in the last few days of his life? An 84-year-old man with Parkinson's, hearing problems, with COVID a few months ago, rotting in jail and then languishing in hospitals. That is up to us to think about and to see how we can fix this system. Thank you for joining us.